The Bentley dispute, David versus Goliath. Now, Bentley Clothing was founded in 1962. In 1982, it registered its trademark in Class 25, which is the category covering clothing. Then, along comes Bentley Motors, the famous car brand, and decides, like many car brands are doing nowadays, to manufacture a line of clothing under its own label. The point to note here about trademarks is that you may not use a name for whatever purpose you like. You are limited to the class in which you register your brand. If you want to extend into other categories, you should do a search to find out if it's going to clash with an existing trademark owner before proceeding. Now, whether Bentley Motors conducted such research or not is something I haven't looked into. Maybe they thought they were so famous that they could own their name in whatever category they liked. As I say, I haven't looked into what they were thinking when they decided to just go ahead with their plans. This action by the motor company led to a trademark dispute with Bentley Clothing. You see, the dispute began because Bentley Clothing became aware of Bentley Motors clothing and approached the car giant in 1998 about the branding clash. In the years between then and when the High Court litigation proceedings began in 2017, the parties tried initially to negotiate but were unable to resolve the dispute. During that time, Bentley Motors made various unsuccessful attempts to cancel the clothing firm's Bentley trademark. Predictably enough, in 2019, the High Court ruled that Bentley Motors had infringed Bentley Clothing's trademark. It could not use the name Bentley on its UK clothing range, and the company was ordered to destroy all clothing featuring the Bentley Motors logo. Bentley Motors appealed to the Court of Appeal and lost. Now, undoubtedly, Bentley Clothing, like any small company involved in a dispute, found the experience of litigation extremely unpleasant and stressful. However, it will have drawn comfort during those years of uncertainty from the fact that its rights were solid. Otherwise, I doubt they would have persevered for so long. This case illustrates that the Davids of this world can beat the Goliaths, provided they build their businesses on solid IP foundations. IP is sometimes disregarded due to the perception that you need to be a big brand with significant resources to bother with IP. This couldn't be more wrong. A small business can ill afford litigation. If you build your business on strong IP foundations, check whether you can use a name and then register it properly in the right way, you will be on a strong footing and can prevail if a big brand begins using the same name. Now, for a business in the really early stages of its journey, if a big player decides to use your name, there's little you can do in practice to stop them if you haven't protected your name. You know, the fact that you theoretically have earlier rights because you use the name first is going to be a really expensive battle which you wouldn't want to risk. So you're completely vulnerable if you're up against the big boys. On the other hand, if you have registered your trademark properly, I say properly because Many DIY trademark registrations that I come across are inadequate. Then you have options. For example, you might decide to sell your trademark to the big brand that wants to use your name. You can get paid quite handsomely, enough to cover your rebranding plus something extra. A big brand would pay you rather than engage in a battle it cannot win. If you do not want to sell your trademark rights, like Bentley Clothing didn't, and have the resources to engage in litigation, then you will be able to argue your case in court with confidence because your rights would be strong enough to prevail over the Goliaths. Now, you do not have to succumb just because they are bigger than you. So the message is clear. Whether your objective for being in business is to earn a humble crust or something bigger, such as to license or franchise or sell your business one day, be sure to pay attention to trademarks when choosing your name. Choose one that is right for your business's overall strategy. People know that the brand name is the single most important decision a business makes, yet what constitutes a good name and the right name for a given business is poorly understood. In my experience, people often feel disenchanted with IP and trademarks, but that's because they chose whatever name they liked, registered it themselves or just got a trademark lawyer to register it for them, and then when they find that their rights are not that strong, they get confused and blame IP law. But if you want IP to serve you, you need to engage with it properly and invest in getting advice at the time when you can avoid ill-considered decisions, which is before you finalize the choice of name. Choosing a name requires expertise in trademarks. A good lawyer experienced in branding can help you choose the right kind of name, not just to search availability and register a trademark. As a general rule, though, if you choose a proper name like Bentley Clothing, you will be on firm ground if the name is available. Whereas if you choose a description, you need to tread with extreme care.